Good evening, everyone. This is Jennifer Kirschenbaum. We're going to get started. If you hear some noise through my phone, I apologize. It's 7 p.m. in New York City, and we have everyone screaming outside of their windows for the healthcare providers that are helping us during this terrible time, which has become a nice, welcoming thing every evening, and that's what's been going on in Manhattan, where I live on the Upper East Side. So thank you to all the healthcare providers that are helping us. I am going to take us through tonight some questions and also the law that's been passed for the Payroll Protection Program that's rolling out mostly tomorrow. So I'll show you what agenda we're going to do. For those of you who do not know me, my name, again, is Jennifer Kirschenbaum, and I'm counsel to Nysos and NYSSO, and I'm available for questions that you may have during this very difficult time. My areas of practice are compliance, transactional, corporate, general operational issues for medical practices of varying sizes. Some of my clients are solo practitioners, and some of my clients have 600 plus or more employees. So I've seen most of it, and I'm here to help. We've spent a bunch of time together over the last 2 weeks, and we've covered a lot of material for most of you who are on the call. Tonight is more so just a quick update on how the law is going to work for the Payroll Protection Program, as I said, and then we're going to go through some frequently asked questions that I'm seeing, and I'm also available to take some questions as they come through on the platform tonight, and we can go through that when we get down to the bottom. So just really quickly, as a quick reminder, we've talked about it before in prior webinars that are available. The Families First Coronavirus Response Act is now active, and we now have to pay people who are still on our payroll and working. If they come in and they tell us that they are sick, they are entitled to 2 weeks of PTO, and that is that they can stay home, and you will pay them for 2 weeks PTO. If they are staying home because they are taking care of another human being that is sick and under quarantine. So just to be clear, they are home because of a federal, state, or local government order or advice of a healthcare provider. That is not the pause order, and that is not an employee that has anxiety. That is for someone who is legitimately quarantined for a medical purpose. They are experiencing COVID symptoms, and they have sought or are seeking a medical diagnosis of COVID. They are entitled to 2 weeks of pay. If it is an individual who is home for any other reason other than for themselves COVID related or to care for an individual who has COVID in their home, they are not entitled to paid time off in addition to what they may be entitled to under your regular policies. Families First also provides coverage for individuals that are caring for a child. That is going to be paid at 2/3 of their regular rate of pay. PTO is also at 2/3 regular rate of pay if they're caring for somebody else. So 2 weeks, they're home. In addition, if an employee is staying home longer than the 2 weeks to care for a child, they are entitled to. They can recover 2/3 of their rate of pay up to $200 per day capped. And that is at a $12,000 aggregate amount over a 12-week period of what they can make. So if you are open, you are running payroll, and your employees are home taking care of a child, they tell you they cannot come in, you will be responsible for paying the employee up to $200 per day during over a 12-week period. Now, why are you stomaching that cost? That's not fair. You will be entitled to money back as a tax credit. I can't tell you for sure when that's going to be paid, but as a tax credit, you'll be entitled to that money back that you're paying out for any PTO. Now, if an employee is not on your payroll or they've been laid off, or you have to lay them off at some time during the leave, then they would be entitled to unemployment. So you do not have to keep them on if you are closing the practice, but you cannot. They could potentially make a complaint if they were on benefit and then you terminated them. So you have to be very careful. If you do terminate an employee that is on the PTO, Families First Coronavirus Response Act, there is a chance that they may be entitled to higher unemployment based on the benefit that's going to be available, but we'll talk about it a little bit later. So just keep that in mind, and we can get through that in the FAQs. The CARES Act summary. The CARES Act that is now in full force and effect aims to put money in the hands of business owners and individuals. There's a $10,000 grant that is available, the EIDL grant, as an overhead replacement. Now, for those of you who applied for that prior to like last week or over the weekend, you likely have to reapply for your grant because the government, SBA, changed its website and changed its application form, and they are requiring resubmission. So if the application you see on the SBA.gov website is not the one that you already filled out, you likely have to submit again, and you'll see information about that on the SBA.gov website. If you receive or file for the $10,000 grant, you will not be precluded from participating in the Payroll Protection Program, which is what we're going to spend our time going through on material, and then we're going to go through some frequently asked questions. The Payroll Protection Program is a forgivable loan that's going to be available to all small businesses under 500, and it's going to be equal to the monthly quote-unquote overhead or payroll cost of the company times 2.5, and it's going to be capped at $10 million. There are restrictions on the use of funds, and if you use them for the right purpose, you can have the funds forgiven. We're going to go through what those purposes are. The unemployment benefit supplement under the CARES Act is $600 per week that the federal government is going to pay out to all individuals that are on unemployment. So that's a massive bump from our $500 approximate of maximum benefit under New York State right now. So let's get into the Payroll Protection Act, because there's a lot of material and I want to get through it fairly quickly, and then we'll handle questions that you may have, and I'll give you my stance on where we stand, and I'll take some questions from the program. There's $349 billion available to give out to small businesses, which is any business under 500 employees. That money we anticipate going very quickly. Banks, which are going to be rolling this out, are going to have platforms available probably starting tomorrow. So if you do not know about this program and you haven't started your work, you have homework ahead of you tonight, and I would speak with your advisors to early tomorrow morning. Our office is already slammed. If you're going to need some help from us, you need to email me tonight, and we'll do what we can to guide you. There might be a delay in tallying because a lot of the banks that we've spoken to even today, they have no idea how they're going to roll this program out. But you're going to apply online at SBA.gov, and it's going to be assigned to your bank where you currently have accounts, and that bank is going to administer the loan. So we'll get through this now. The Emergency EIDL grant, here's some information on that. You can use the funds that you receive from the grant, no strings attached, except you have to use them for providing paid sick leave to employees, maintaining payroll to retain employees, and meeting increased costs to obtain materials unavailable from the supply chain. You're going to have to warrant that you've had some reduction in revenue, which is not hard for many of us. You're allowed to use the money for rent, mortgage payments, and repaying obligations that cannot be met due to revenue losses. This is a no strings attached grant. Now here's the unemployment grant language that comes from, this is a law section. If an applicant that receives an advance under this section transfers into or is approved for the Payroll Protection Program, the advance amount shall be reduced from the loan forgiveness. So I've had a lot of follow-up questions of, I heard that if I get the grant, I can't get into the other program. It's right here in the law. This is the language direct from the law. You absolutely can get into both programs. Allowable uses of covered loans. If you receive money during the covered period, which is going to be, we're going to get to it, but it's going to be the 8-week period from when you receive the funds, you will be allowed to use the money for payroll costs, costs related to continuation of group health benefits, employee salaries, we're going to get to everything that's included, payments of interest on any mortgage obligation, rent, utilities, and interest on any other debt obligations that were incurred before the covered period. That's what you can use it for. Here is how you're going to determine the amount you're entitled to. It's going to be based off of your payroll costs, which is going to include salary, wages, and other similar compensation, payment for vacation, family, medical, or sick leave, allowance for dismissal or separation, payment required for provision of group health and health benefits, payment on any retirement benefit, and payment of state or local taxes assessed. You can also include money paid out for 1099s. That's going to be included. Independent contractors right here. It's not going to include compensation of an individual in excess of an annual salary of $100,000. So for anyone that you pay, including yourself, if you make more than $100,000, you cannot include for the loan amount anything more than 100. So you're going to look at your payroll and you're going to cap everything that you're calculating for each individual person, and it should not show more than $100,000 on an annualized basis for any individual. So you're going to have to reduce the total payroll that's going out likely with these caps in mind. Maximum loan amounts. Any for-profit business, which we covered, of 500 and less is entitled to the sum of the average total monthly payments during the 1-year period before the date on which the loan is made. That's what we're going to consider. Now, on the loan application, which is interesting, this is the actual law language. It says that most people will use 2019 as an easier period of time, and it appears that the Treasury is going to accept that time frame. So you can use 2019, or by the law, you could use the 12 months prior to the loan date, which you probably don't want to do because many of us have seen tremendous shifts in our payroll the last 2 or 3 months, or 1 or 2 months rather. You're going to multiply whatever number you come to with a payroll expense by 2.5, and that is going to be the amount that you are entitled to under the loan. You are going to cap the amount you're entitled to at 10 million. If I have any large practices listening, that's the cap, is 10 million per company. Now, this is for anyone who is not in business, which I'm not going to spend time on because all of us were in business, I'm assuming, as of February. To be an eligible recipient, you need to make the following representations on the application: that the uncertainty of current economic conditions makes necessary the loan. The funds will be used to retain workers and maintain payroll. Now, since the law has come out, we've received more clarification. You will be allowed to use only 25% of loan proceeds for items other than payroll. And so you want to be careful on how you use the funds once you receive them, because use will impact forgiveness. So if you're expecting this to be free money from the government, you better be very, very careful how you document and deploy the funds. And that's going to be the key here. This is for our lenders' lending consideration. They're going to look at and make sure that all applicants were in business as of February 15th, 2020, had employees, paid salaries and payroll taxes, or paid independent contractors. This is what they're considering. The lenders also have the authority to make loans, and it shall be extended to additional lenders. So this is the banks getting the authority to make the loans, and this is the actual language. These will be non-recourse loans, which means that you will not have to give a personal guarantee, and there will be no collateral for these loans that is required. So during the covered period, the bank that is loaning to you is not entitled to take a fee from you. The fee to the bank is going to be paid by the government from a different apportioned amount of money from the Treasury. You do not have to worry about fees related to this loan. There will be interest, which we'll talk about right here. A covered loan shall bear an interest rate not to exceed 4%. Principal and interest are going to be deferred for not less than 6 months after the issuance of this loan. So you're going to have a lot of room if you don't qualify for forgiveness to start paying this back, and the interest is going to be fairly low. In case you were wondering what the banks are making off of this, this is the rates that the banks are entitled to from the government. If you're wondering why your bank may not be so excited about this product, this is why. If you think about what you have to pay your bank for a loan, you have upfront costs typically, and then you have an interest rate that is very usually much higher than 1% or 3% on these amounts. So that's why you may not be getting a lot of rush of excitement from your banker to help you get into this loan. An eligible recipient, so someone who qualifies, shall be eligible for forgiveness of indebtedness on a covered loan in an amount equal to the sum of the following. So you can get forgiveness on money, assuming you requested the proper amount, spent on these things: payroll costs, any payment of interest on any covered mortgage obligation, any payment on any covered rent obligation, and any covered utility payment. You will be entitled to forgiveness. Covered mortgage means for a property that you purchased before February 15th, 2020. The covered period for when you're entitled to forgiveness is going to be the money that you spend from the minute you get the loan and 8 weeks thereafter. That is going to be your covered period of time that you can spend the funds that you receive. Now, again, you're going to have 8 weeks to spend, and what you spend during that time will be likely forgiven, so long as you spend it only on payroll costs, payment for a mortgage, payment for rent, payment on utility. So we're going to be very careful how we spend it. The amounts that you are spending, treatment of forgivable amounts. Let me just get to the tax language here because this is what's important. We're going to come back to the limits. There's going to be, it's going to be forgiven, and it's going to be considered cancel indebtedness for all amounts that are going to be forgiven. Now, the lender, I have this on a different slide, is going to have, I believe, 60 days to make a determination on the forgiveness of the loan. There's going to be a potential reduction of the forgivable amount based on whether or not you maintain employment through June 30th of 2020. So to be clear, many of us who have already terminated employees, you will not be penalized for that action. You will have 30 days to rehire your employees from the date of the law being passed, which was last Friday. So we have a little while, a couple of more weeks, to bring everybody back, and we have to maintain their employment through June 30th of 2019. Otherwise, the amount of forgiveness will be proportionately reduced. So here's the reduction calculation in the law, so you can just see some of the language. In addition, what we have to be careful on, here is the language on the rehires. For loan forgiveness, there shall be determined without regard to a reduction. So here we go. There's going to be no consideration for reduction in the number of full-time equivalent employees of an eligible recipient, or a reduction in the salary of one or more employees of the eligible recipient as applicable during the period beginning on February 15th, 2020 and ending on the date that is 30 days after the date of enactment of this act. So we have plenty of time to bring back those employees that may have been terminated between February 15th and now, and 30 days after the act. And if we do that, then we will not be dinged on the forgivable nature of the loan. Your application for forgiveness is going to require more information than the application on the way in. On the way in, the application is seemingly pretty straightforward, and the government claims it's going to take you 8 minutes to fill it in. It actually says that on the application. That may be so, but there's plenty of work to figure out what material you need to put into the application. There are nuances in this law on how to calculate the payroll that can trip you up and have you taking an amount or thinking you have the right amount, it's the wrong amount, and then you will not be set up for total forgiveness of your loan, or you might be setting yourself up for loan denial, depending on how the bank is going to administer funding. But the thought process is that the banks are not going to have much time to process. So they're probably going to, knock on wood, grant all of our applications that go in a timely manner and give the funds out. And then they'll probably worry about whether or not they pay the right amount on the back end. So as a practice owner, and a practice owner, looking for liquidity right now, but mostly looking forward if it's going to be forgiven, we need to be careful on how we determine the numbers on the way in, because again, there's not going to be that much, for lack of a better way to frame it, claim scrubbing going on the way in. So we need to be careful, and we need to have the support available. Payroll tax filings, state income, payroll, unemployment insurance filings, these are all going to have to be potentially presented for forgiveness, and the documentation is going to have to be correct. The administrator is your bank also, and they're going to be able to ask for any information that they think is relevant for the forgiveness. So the forgiveness program is going to be a lot more involved, probably similar to what you've experienced when you've taken other loans out or a personal mortgage. There's a lot of documentation you have to produce for the bank to give you what you would like to see. So decision, not later than 60 days after the date on which the lender receives the application for loan forgiveness, they have to tell you whether or not you're going to be approved. The good news here on this loan is that, I don't know if I mentioned it yet, is that there's no prepayment penalty, and I did say that interest is going to be very low. So if you find out fairly quickly, because you only have 8 weeks to spend the money that you're getting in on an approved purpose, if you find out within 60 days after that point of applying for forgiveness, which there's no guarantee when you can start the application for forgiveness. I don't know when that's going to be available by your lender, but let's say it's available after the 2 months after the first amount of money is going out, then let's say you have 60 days thereafter to wait. So now we're 4 months in. They're told you already that there's a 6-month deferral period for any principal or interest. So you will be in a very good position to repay any overage if you accidentally ask for too much. Now, if you ask for way too much and there's potential fraud in your application, then just like all the other areas that as healthcare providers we're very familiar with, there will be significant ramifications. So we want to try to be as on target as we can with our estimates. We're certifying a formal application to the government, so veracity is key. It can be complicated. Plenty of people are going to miscalculate the payroll cost. That's why it's important to work with your banker, your lawyer, and or your accountant to just make sure that this is done correctly. Now, why do I name all three? Well, your banker has to process it, and right now, from what I can tell, most of them don't really understand the law. Your accountant doesn't understand the legal, and your lawyer doesn't understand all of the financial materials. So it's kind of a team effort getting these things finalized properly, and more so the forgiveness application is going to be the bigger issue. So I did give you all the material here that you will actually need to finish the application because we went through all the payroll costs, and you can certainly review. I'm happy to give these slides out, and I know we've all been briefed on a lot of material probably from all the lawyers and accountants that are emailing us, and most of the information that I've seen out there is mostly correct. So, and any questions that you have, quick questions, you can always send me an email as well, and I'm happy to help. Maturity for loans not forgiven. There will be maturity issue for loans that are not forgiven. They're going to continue to accrue. They're going to continue to accrue interest, which is probably a much lower rate than we probably have on any of. Oh, Robin is telling me that there's no slides showing, which is not good. Oh my goodness, Robin, do you want me to start again? I didn't realize that. That's my mistake. So, okay. So apparently there's no slides. This is horrible, and I'm very sorry. I'm just going to back up, and I'll show you quickly some of the main things that I've been talking about, and I'm sorry, but there's no slides. So let's go through the payroll cost, which is right here. I said it. Hopefully you were listening. Salary, wage, commission, payment of cash, tip, which is not relevant, vacation, severance, payment of any insurance premiums, payment of any retirement benefits. All of these things are what's going to be the amounts that can be determined for the loan, okay? Payroll costs. So you're going to sit down with your payroll records, and I'm sorry for repeating myself, but now you can see, which I think is very helpful for visual learners. Salary, any compensation, and we're going to get to the FAQs that have to do with physician comp, but as I already said before, you can include your salary. If you're making above 100, include it, but cap it at 100. So when you sit down, back of a napkin, you're writing out what everybody makes, you're going to write doctor, $100,000 annualized salary. You're going to put the full payroll for 2019 for everyone else down on that sheet, and then you're going to divide it by 12. Prior to dividing, you're going to add in the group health insurance and the payment for state and local taxes, okay? Federal is not included when you add up everything in here that you want to put on. Okay, so just to show you, again, cap of 100,000, okay. The maximum loan benefit we talked about already, it's going to be 2.5 times the payroll cost, which we just spoke about, and I'm going to go back through. So the lender considerations, you don't need to see this stuff we already talked about. Loan forgiveness, we talked about. You can spend it on payroll costs, any payment of interest on any covered mortgage, any payment of any covered rent obligation, any covered utility payment. You cannot spend it on mortgage of a property that you just purchased. So just be careful there. The covered period is the 8-week period from when you receive the money. The money is going to be considered canceled indebtedness. It is not going to be included as earned income, part of your gross income at the end of the year. So you will not receive a tax sting because you are participating in this loan. Okay, so we're mostly through the material. I can answer questions on it as we get through our questions. If anyone wants to go back to any of the slides, I'm happy to make the slides available, send them to Robin tonight as we finish up, and you can peruse them as you wish. And I'm happy to answer any questions as you go through them. We talked about maturity, so I want to get to questions because I don't want to take too much of everyone's time tonight, and we spent a lot of time on materials the last 2 weeks. The federal stipend, again, for everyone on unemployment is $600. I want to spend some time on this for a minute because it's going to get into some of our frequently asked questions, and I have a lot of them that I want to get through in the next 15, 20 minutes before I release everyone for the evening. The states administer the unemployment programs, and the states have their maximums that they pay out, and the states have their rules on how they pay it out. The law says, that was passed with the CARES Act, says that the federal government is going to pay every recipient on unemployment in every state an additional $600. They're going to have the state administer how they're going to pay the $600, but the rules are the $600 has to be paid per week to the individual. The state can also adjust its payment to the individual unemployment. So, do I think that the states are going to be administering the equivalent of, let's say, a $55,000 a year salary to everyone on unemployment? No. If you take the 500 and something that the New York State already gives, and you add 600, that's $1,100 a week. That's the equivalent of approximately $55,000 a year salary. New York State is not going to be paying that to our employees that are on unemployment that make, let's say, $42,000 a year in salary. New York State is going to lower what they would be normally paying, so that way the employee is receiving a fair wage. I do not know yet if that fair wage is going to be equivalent to the employee salary or just below. But I certainly do not believe that the government is going to put individuals in a place where they would rather stay on unemployment than go back to their job. As a matter of fact, one of the legal requirements for collecting unemployment is you have to not have an employment opportunity. So they are definitely going to be looking for people to go back to work. So I want to go through some frequently asked questions that I've received already on, and also from some of our members on today. On the CARES Act frequently asked questions, can a sole proprietor qualify for a grant or a loan? The answer is yes, all three. a sole proprietor can file for the EDL grant, the $10,000 grant that I discussed. They can also file for the Payroll Protection Program loan. So either or both in this instance, you can apply for. In addition, a sole proprietor that does not have a corporation, if you are completely closed, you can also file for unemployment. And an individual that owns a corporation right now is not authorized as the shareholder to file for unemployment in New York State. New York State requires the corporation to be completely dissolved, not just inactive, but dissolved, for the owner to file on unemployment. What if I go for the grant first? Can I still get the overhead replacement forgivable loan? Yes, you can still qualify for the loan if you apply for the grant. So the reason why I think the grant is a good idea is the government's going to run out of grant money. The government is going to run out of Payroll Protection Act, a program money. They're going to run out of both tranches. So I don't recommend not applying for the grant because you're holding out for the loan, because I don't know who's going to get any of it, because it's definitely going to run out. Can my banker help me with this? Your banker has to help you with this. So if you have not contacted your bank, you have to, because the only way you can get this loan pretty much is to go through the bank that has one of your accounts, preferably your business account. So please send an email while I'm talking, if you have not already, to your banker and find out if you can get in line, or if they have you in line already, great. And ask for more information on their particular program, because each lender is going to take the Treasury regulations and roll out somewhat of a different system, maybe how they're going to ask you to send the applications in, if they have an online portal. Those things are going to be different bank by bank. How am I going to qualify for forgiveness? That's a good question, and you have to start thinking about that now. You're going to use the loan proceeds in a manner that are in line with the law, and you're going to put the application in. So this is where the lawyer would have to come in if you need help on this or any clarification. If you don't think you're setting yourself up correctly for forgiveness, then you need advice, and you need to get the right amount on the loan on the way in to make sure that you're going to be set up to properly qualify for forgiveness. Is there a likelihood of audit, like a payer audit a few years from now? Absolutely, 100%. There will be a whole industry on fraud and abuse for this loan alone. And then, of course, for everything else that's happening during this time period that's stimulus-wise. I would imagine there's going to be tens of thousands of people, if not more, employed, just like safeguard services, to be monitoring the integrity of the money that's being sent out right now. Please clarify average monthly salary of which designated 12-month period. So again, I am not clear on this exactly, but I'm going by the application, because the application says the full year of 2019. So that is what I would go by, and I would average that amount. Please confirm that the employee salary absolutely excludes your own. That is absolutely not the case. The employee salary, you can absolutely put your salary in with the employee salary. And I just want to take a minute and go through again what that means. So you are going to figure out what you make, okay? And from there, you are going to cap it at $100,000. You are not going to be able to participate at a higher number than that. And it's not super clear what that means for with a group health insurance. I don't think that it's going to be easily accessible on that. We're not going to have full clarity on everything that we're looking to do here right now, unfortunately. So in order for us to just apply, we have to make sure that we have Sorry, I'm having some computer issues on my end. Just give me 1 second. So for the amounts, we have to make sure that we have calculated as best we can the correct numbers. So what are the correct numbers? That's a good question. I can't really answer that because I'm not sure how everything's going to be calculated. But my best guess is that the group health insurance is going to be capped. So I think that we need to be careful on how I would not include the group health insurance above the 833 number, which is the applicable number for the cap, the $100,000 a year salary. Okay, so moving on. Okay. Sorry, I hope there's no feedback on your end. Okay, so I'm just waiting for my computer here to change the slides. All right. Unemployment-related FAQs. It is necessary to have a Department of Labor work plan for our employees to collect part-time unemployment. Under current conditions, do we need a skeleton crew for half days, a week? So let's talk about that. You do not need a Department of Labor shared work plan. You can have employees working part-time. That's completely fine. Okay, so we are going to talk about, how do I go back here? I'm sorry, you guys, I'm having a lot of problems with the computer. Okay, so, oh good, my internet's back up. Okay, so most of us have closed our office for most of the time now, right? Some of us are open for emergencies only, which is completely appropriate because we're allowed to do emergency care. So with that being said, how can we keep our employees on staff and how can we pay them? And this is a major question that I've received from, I would say, hundreds of employees over the last, I've received at least 100 emails on this over the last 2 weeks, is how do we have our staff be out of work and also utilize them if we need them? And the answer is very simple. You are allowed to utilize your staff on an hourly basis, assuming that they're hourly employees, and we'll talk about physician employees that are contracted in a few minutes. You can have employees on benefit, and then they're entitled to work part-time. So this is straight from the unemployment website. What if I work part-time? How do I collect for benefit? If you work less than 4 days a week, and this is not updated with the stimulus benefit of the $600 a week that's going to be available. If you work less than 4 days in a week and earn $500 or less, you can receive partial benefits. So what happens is the employees go online, they file for unemployment, and they put in their information on what their wages have been historically for the past 8 weeks. And then they qualify for a number that they're entitled to per week. And now it's going to be $600 in addition to whatever the state decides is their maximum. If they work more, their wages are going to be reduced if they work more than even 1 hour in one day. And it's going to be a complicated reduction on how the state's going to figure it out. But you, as the employer, your obligation is for the employee to know the status of their employment. And once they've been terminated, the employee can file for the unemployment, and then each week, if you have them work 2 hours or 4 hours or 6 hours that week or 8 hours, someone comes in to open the office for you, they're helping with sterilization of equipment and the space, they're doing follow-up calls, they're helping with billing, whatever it is you may be using someone for. You are absolutely entitled to ask them to do that. They could potentially say no. And if they do work, for whatever hours they work, it's their obligation to report to unemployment how many hours they put in. So for most of our staff, what I'm finding, they are more than willing to come in for those hours during the week. for the most part, unless they have a medical reason or specific anxiety. They have been willing to answer the call for the majority of my clients. There are a few that are not willing to come in. Now, remember, if they're refusing to come in, but they do not have COVID, or they're not taking care of somebody else, that's not a reason to pay them for paid time off unless they have accrued PTO with you and you have not terminated them. So, and this is all prior to receipt of our loan, right? If you qualify for the loan, you're going to have to hire everybody back, and then you're going to be subject to the PTO benefits that you're required to provide for, which is going to be covered under the loan proceeds. Or if it's not going to be forgivable, you'll be entitled to a tax credit for paying that money out during this period of time. So it's going to be very complicated. There's going to be a lot of follow-up questions that have to be had, and possibly we'll put together a frequently asked question Q&A in writing for the societies that Robin can disseminate, and I think that would be probably a pretty good benefit that we can offer. So we'll put that together over the coming weeks on, how do you answer some of these employment questions as they come up. If we recently laid off our staff, can we still get repayment forgiveness as long as they're rehired by June 1st? The date for rehire is not going to be June 1st. It's going to be, I believe, April 26th. So you have to have your staff back full tilt by April 26th, and you have to maintain their employment through June 30th. Now, let's just walk this through for a minute, and many of you have more information on this or believe you have a better understanding of this than probably I do, because I don't have much confidence in when we're going to be really back to work and when you think your patients are going to be back in your offices. But let's just play this out. You apply for the loan tomorrow. Funds start flowing next week or the week after, right? So let's say that puts us at, for convenience, April 15th, okay? You have 2 months to spend your money, and then you're out of money for forgiveness. So you're going to try to spend everything that you get, your 2.5 times your payroll cost, in that 8-week period, right? You spend it all. It's June 15th. We may not be at full freight at June 15th. Very likely, you'll tell me if I'm correct, but the faucet will maybe be open a little bit, and maybe you'll have a couple of extra days than you do right now, and you may not need your staff full time. You are required to carry everybody until June 30th at a minimum. And if for some reason we are delayed on our full comeback, then there likely would be probably additional stimulus available, but I'm not holding my breath on that. But at that point, your forgiveness number would not be impacted if you had to terminate people after June 30th. Now, just because you don't maintain staffing levels or you don't bring everyone back doesn't mean that a portion of your loan is not going to be forgivable. It just means that the percentage of the loan that would be forgivable is going to be impacted. And again, if you do not receive forgiveness, whatever portion you do not receive forgiveness on is going to maintain a low interest rate, 4% or less. It's not going to there's going to be a deferment period of 6 months on any payments having to be owed, and the loan maturation period would be likely 10 years. So it's not the worst thing if you do have to repay it at a later date. You'll be able to do so once you're up and running. And if for some reason you do not reopen or you do not stay open, you are not signing for this loan personally, and you are not offering any collateral for this loan. So at that point, the loan would be forgiven, or if you were going into a bankruptcy, or potentially the government could come after the practice, and that's it. So my office has an established PTO program. We used a portion of it to cover our last payroll and had planned to do the same in 2 weeks. However, the passage of the Families First Act is just no longer allowed. So I don't really know what a PTO program means, a paid time off program. I'm assuming this just means that you provide for PTO. The Families First Act has nothing to do with your already promised PTO to your staff. The 2 weeks that you are required to give is in addition to what you were already offering to your staff. So that has to be really clear. And it's only for people with COVID. It is not for any other reason. It's for people with COVID, quarantined for COVID, or caring for someone diagnosed or seeking a diagnosis of COVID. So it is in addition to. You were using your PTO program to pay your last payroll. I don't know what that means either. It sounds like you're just paying wages with amounts that possibly you have saved for PTO. You can't really force people to take PTO. We can talk about that. They either are working or they're not working, or they can choose to apply it. And if they should be all hourly employees, most likely, they would not be entitled to money if they're not working. So I am concerned with that question that it might just be almost bonus. So we would have to talk through that a little bit more. Okay, if you laid off all of your employees and they need to live off New York State unemployment insurance and an additional $600, are we able to hire them as independent contractors? If so, then this will have to get recorded for staff as current wages and their unemployment benefits would decrease. According to my staff, it's not worth working even 3 to 4 hours in office at all, since their unemployment will get reduced too much. How are we supposed to at least continue with some staff in the office to avoid complete bedlam when we return to PT or FT hours? I completely understand this question. Let's go through it in parts. And so much of this is messaging with the employees, so much of it. So if you need help with that, if your office manager is not particularly skilled with this, you can always call me. I'm here to help. I get stuck doing this a lot. I'm happy to help you, but a lot of it's messaging with the employees and presentation. Everything that you are doing right now or have already done, laying them off, working to try to get these loans, trying to keep the place open. Of course, it's for you and it's for your benefit and it's your practice, but it's for them too. And so that they have a place to come back to and you have a place for your patients to come and be treated and you can care for the community. So, the messaging to the employees is so important because they have to understand that this isn't about who's paying them and who's paying them the most necessarily. It's about how are we going to get through this together? And you need them and they need you. So it's a symbiotic relationship here. And if they want the doors to be open and they want patients to come in and they want to get off unemployment and they want to return to our post-COVID new normal, which is, hopefully going to be us leaving our homes, then they need a practice to go back to. And so I've seen really just beautiful responses from many human beings during this last couple of weeks. And I think your staff will surprise you. And I think a lot of that comes to messaging. So if you laid off all your employees and they need to live off of New York State unemployment, an additional $600, you can't hire them as independent contractors because they don't qualify as independent contractors. They're still going to be employees. Remember, and this is another topic for another time, but independent contractor versus employee is a multi-factor test that's governed by the IRS based on control and supervision. So your employees' job descriptions haven't changed. They will not qualify as independent contractors. If so, will they have their unemployment benefits decreased? Yes, potentially on a week-by-week basis if you need them 2 hours or 6 hours or 8 hours or 12 hours. Yes, they've filed. They will report whatever they receive to unemployment. Their benefit may be decreased. I understand that. That's the answer to that is yes. According to my staff, it's not worth working. Again, that goes to the messaging. They need a place to come back to. So if you need help with the messaging, I'm happy to assist. But I would just be honest with them that you need their assistance so that way there's a place to go back to. You need them to help you so you can help them. They have to schedule patients for May, or if you don't think May is going to happen, then they need to push everybody out to June, and we need to get people back on the books and see our patients for follow-up visits and keep the place open. How are we supposed to at least continue with some staff? Well, I think we already answered that, so I'm going to keep moving, and I'll see what other additional questions have come in when we get there. I showed you this slide. This is straight from the frequently asked questions. The frequently asked questions on the Department of Labor unemployment website are very, very helpful. They have a lot of information on there, and your employees should certainly spend time on there. This is the most difficult slide that I have to address tonight, so I hope that you guys have hung in, and I'm sorry about the issues before with the slides. And again, I'll send that out to Robin tonight so that way she can share. Okay, so employment frequently asked questions, employed positions concerns. Many of us on the call are employed or have hospital relationships that we're concerned about at the moment, and we can talk about that. Are there any benefits available for MD employees who are productivity based and whose salaries have been reduced during this time that work is limited? Yes. Independent contractors alone can qualify for loan constructs, which is up to, so an independent contractor can file, him or herself or a sole proprietor, for this payroll protection program, which again, applications are really getting going tomorrow. So this is a little bit late in the game, and I apologize. We didn't know when we booked this exactly when the loan is going to be coming out, and then it's hard to move these things in advance. So you absolutely, if you're an independent contractor, you can possibly apply for the PPP and some other stimulus benefits. An MD employee is eligible to file for unemployment, which you may or may not have ever done in your life, and you may never have considered filing for it, but the annualized salary that you would be entitled to is likely going to be about $55,000 a year. And I encourage you, if you are not receiving any money during this time or even a reduced amount, you may very well qualify for unemployment, and the money is being supplemented by the federal government. There is no reason not to file a claim. Just file a claim, okay? You can consider it a civics lesson. So that's up to you, but I would recommend that you can file during this time period. You also are owed money from the period of time that you worked previously, and that's a conversation that you're going to have with your employer. Your employer knows that they have money to pay you based on your productivity, and when operations resume, they may be asking you to take a deferment right now on money that is due to you due to the cash crunch. And I understand, and you should just work that out with them. I am an MD employee, and I am 100% productivity based. Are there any benefits for physicians in this situation? I've gotten this question a lot, so I'm sorry it's duplicated. The same question. Again, unemployment benefits is what I would recommend filing for right now. Many will not qualify for the additional $1,200 subsidy per individual because the salary marker is $75,000 per person. The practice I work for is open and claiming we are essential and the services to be rendered are emergency. I do not agree. Do I have to go in? If you're working at a private practice and the owner is open for what they consider to be essential services, we went through last time, and I didn't put the triage list on here that's available and somewhat relevant to our specialties. But there are lists from the professional associations that offer guidance that may be persuasive to your employer if what you find on there is not adding up to the visits that are being booked. If you personally do not believe that the services are essential, I would look to bring that guidance to your employer's attention first, and then I would, if you're just refusing to go in, then likely it's going to be a contractual issue, and the employer may start looking for reasons in your contract to possibly terminate you. So just be mindful of that because you're operating under your agreement. So it might be time to take out your employment agreement and see, what that document says and whether or not you have to go in. But you might just be in breach of contract. It's going to be a contract issue. So this is the harder one, okay? And I've gotten more emails than I want to think about this one, but the hospital I work part-time at may call me to the front lines. Normally I have no issue answering the call, but we are running very low on PPE. Do I have to go in? I have heard, we were waiting to see if this is going to happen, but I've heard that one or two hospitals I've heard in the city, certain individuals were threatened with licensing action. I'm not telling you this to because I want to be an alarmist. I was receiving questions in advance of me hearing that this happened about doctors who were concerned about this happening. And I did hear of 2 or 3 instances where this did actually happen. It was probably a very frustrated administrator, and it was probably a very frustrated physician. I know we're at somewhat still even the beginning of what's happening here. What I would say is that, look, I wouldn't try to just hide under a rock. I would try to figure out how the scheduling is going to be going. And if you maintain privileges at a hospital, or some of you may in signing on with privileges, I've seen in part of possibly having a part-time employment agreement with a hospital, you're also possibly signing on to a union that's related to the hospital as well. And between the union contract, between the hospital privileges, and between possibly an employment agreement, there may be language in there that requires you to answer if they want to change your schedule, or you may have given the hospital the authority to dictate your schedule, which is not unusual in a hospital privileges agreement or hospital agreement. So there might be that language in there. How you're going to handle it, I think, has to be determined on a case-by-case basis and what you're being asked to do. This is a critical time, and I don't have a great answer for you other than that. So we'll have to see what's going to happen. Now, one of the biggest concerns that you should have, and I don't want to encourage anyone to put themselves in an unsafe situation, but you need to avoid any potential claim of patient abandonment, because that will be a problem where if you're reported to OPMC, that is a very difficult claim. And during now, we're in an impossible time, so there will be that consideration. But if you are there at the hospital, you must try to finish at least the shift that you're on. If you have problems with additional shifts, you have reasons why you can't go in or you shouldn't be scheduled, then that needs to be discussed. And I'd also recommend documenting. Be sure to put those answers into an email and send them not just to the scheduling coordinator, but also the chief of your department. And that's the best advice I can give you. You can feel free to reach out to me on a case-by-case basis. I certainly encourage you to, and we will handle now. If you are having a problem with your hospital, we have to document now for later, okay? Because there will likely be a deluge of all kinds of complaints that come out of this that are going to be difficult to work through. But if we can properly document and show, as much compliance as possible, that would be best case. So I'm going to try to read the questions that have come in while we've been on here, which would be a lot easier if I could read them a lot easier, because it's very difficult to see on this platform, the questions. We have a lot of questions. So I'm going to go up to the top and spend some time going through. Already 8 o'clock, so this is more than I thought we were going to do tonight, but the questions are really important. We have way too many questions to get to tonight, guys. There's got to be like 60 questions on here, so I'm going to try to get through. Can we include pension plan and payment for payroll for staff in a 75% requirement when we do this? I believe the answer to that is yes. I will send a definitive answer. How do you submit information about utilities overhead? There's no error in the application utilities overhead. You cannot consider utilities overhead in the amount that you are asking for. Okay, you are going to just, the loan amount is based off of the just the payroll cost. That's it. And then and it's multiplied by 2.5. So remember, you only get 2 months to spend it. So that 0.5 is what they're expecting you to spend on non-payroll expenses. So that's why you don't see anywhere in the application to indicate what your utilities are, because they don't care. They're not basing it off of that. We don't apply to our usual a bank directly, but to the SBA website. Is there a way to apply directly to the banks, minus Citibank? You will be applying potentially or likely on the SBA website, and then your bank is going to be assigned. Certain banks are giving different rules and asking you to please apply through their portal. So again, it's not clear, and this is supposed to open tomorrow in the morning. So we need to see where this is going to go. With the Payroll Protection Program, one is eligible for 2.5 times. Yes, yes, correct. Rents and utilities are not included in the amount that can come in. Are you aware of which banks may be ready tomorrow to accept applications so we can get funding? The big ones are they should be. BAML, Chase, I know, has a program, although their informational session tonight was not helpful. Signature Bank, I know, is doing it. which is smaller, but TD, the big ones are. The calculation for PPP loan grant, do we subtract out federal payroll? Yes. Federal payroll is not included, it's just the state. So there's a lot of calculations that go here. Another utilities question. Okay. Yes, I see you did not have access to the slides. I'm sorry, guys. It's been a very long week. I thought that I hit show the slides. Do you recommend opening a separate account? I absolutely recommend opening a separate account for these funds so you can properly segregate. We have a payment obligation to an associate from January. Can we make this payment? My answer right now is I believe yes. You are allowed to pay accrued debts and also accrued commissions and payroll amounts. So I think you could use this money, the extra that you're going to have, to pay down some of that productivity that's owed to some of your physicians. I filed as sole proprietor. How do I qualify and file? And for my lease and everything else, same thing. You're going to file online. The lecture will be available. Again, I'm sorry for the technical difficulties. During the 8 weeks when forgiveness is determined, is it necessary to limit the salary of a highly compensated employee to 100? You do not have to limit your compensation or anyone else's compensation to 100,000 during this time period. However, you will not be able to get forgiveness on an amount that is more than 100,000 expenditure. So that's up to you. If you want to just use it as a straight loan to pay someone more or some people more. A lot of physicians have been understanding and willing to accept the salary decrease during this time, which if you have contracts with your doctors really should be done contractually. And I've seen very large systems and large private groups, PE-backed groups, sending disrespectful contracts out that are, pennies on the dollar with what the doctors make, and they give the doctors no time to sign, and it's a bit of a disrespectful process. But if you have individuals that you want to discuss a change with, then I recommend that you speak with them first, and then from there we can talk about a contract change if necessary. Which it would be necessary because their doctors are continuing to accrue as they would. So if you have a base salary out under there and you are hoping to have it canceled during this time or abated, then that needs to be documented in writing now. Otherwise, you may have a contract problem later. Okay, non-payroll, the other 25% that you can use it for would be rent, a mortgage payment, and debt indebtedness. Okay. Yes, I will make the slide deck available. Mortgage payments, yes, are included as explainable. Okay. Malpractice amounts for insurance are not forgivable, is my understanding. The application itself that you're going to be filling out, and this is to the question of my bank has no idea what's going on. And I don't understand why that is. I'm sorry about that. But the application is on the SBA.gov website. So just type in SBA.gov. You'll see Payroll Protection Program. It's a 4-page application. Read the whole thing. If you have partners, you have to list all the partners' affiliations that have, there's a 20% precipice of if they own other stuff or if they own a certain amount of your facility. So, and we also have to be mindful, some of us have surgery centers that we are affiliated with, and we have to be mindful of the affiliation requirements under this law. It's not just going to be your one solo practice that you might have to file with. If you own a certain amount or there's control issues between, not control issues, but if there's a joint control and joint ownership between multiple entities, you may potentially qualify or have to file as a consolidated. So there's legal issues that have to be checked here with these applications. So please be mindful of that and make sure that you're consulting with your attorney, or and if your accountant has no clue about this stuff, you have to call an attorney. I don't have a worksheet on how you can calculate, but I'm happy to help. Will the interest payments at the end of the loan be forgiven? That depends on if you qualify for forgiveness. I'm not exactly sure how that's going to be treated. It looks to me, I thought I saw that they were going to, but then we'll see how it's actually going to be rolled out. So I'm not crystal clear on whether the interest is going to be totally forgiven. How long does it take to hear back from the lender institution? I don't know. It's going to depend on the lender on how they're processing. I also don't know how the money is going to be dealt out. If it's going to be order of priority based on when the application was actually submitted through SBA, or if each individual lender is going to be given a tranche of money. I don't know that. Will part-time employees receive the $600 per week in calculating the payroll cost? Supposedly, everyone on unemployment is supposed to be getting the $600 in addition to what they qualify for under the state. I don't know how the state's going to roll that out. What state tax is included in the calculation of the tax withheld from salary? You have to just take a look at your payroll reports and breakdown, but federal is not going to be included. So look at your payroll reports. Can I help with this? I can. Again, the timing is very tight. So if you need to call me on any of these questions, please send me an email. That's the best place to start. And maybe if I can answer it quick, that would be great. If we have to set a consult time, we will. Does the money from the loan need to be in a separate account? This is already asked. It's a very smart question. Another smart person asking this. I recommend that you put the accounts as received in a separate account so it's easier to track and document. Assuming we take more money in the loan than is needed, that maybe you screw up the calculation or whatever, I pay back the portion I don't use for the designated expenses. Yes, you can prepay it with no penalty. The interest may accrue as of that point, but it's going to be very low. So you'll pay back with the funds you receive. That's fine. You have nothing to worry about then. Can I help you figure out the categories for the sick pay and child care if we're paying full salary? Yes, that's what I'm here for, guys. You can call me. This is my only way to contribute right now. So I'm happy to help. What if your current payroll is half of 2019? Your payroll is going to be, let's be really clear, you're going to use your payroll numbers from 2019, and you are going to not be penalized for having fired people already, okay? And you don't have to bring people back right now because you think that this money is going to hit your account. Do not make any changes to your current staffing levels if you've already fired everybody. You will bring people back when you know you're getting this money, if you get the money. Employees are refusing to come back and apply for unemployment on their own, but I told them they're not fired, they're furloughed. However, she refuses to work. What do you think that I should do? I think you should fire her immediately. That's what I think you should do. And I'm happy to help. How do we apply for the $10,000 grant? If you want to email me, I will shoot you out very quickly where to apply for the $10,000 grant. It's on the SBA website. It's right near the PPP. It's called the disaster loan, and it's right underneath. You should see it. But if you don't see it, I'll send you the link. Do I apply for the PPP through my bank or online? I believe you're going to have to submit the application on SBA.gov, and then your bank is going to be assigned. That's what you had to do for the EIDL grant as well. As a sole proprietor, I do not pay myself a weekly salary. May I use my earnings reported on my tax form from 2019 as salary max of $100,000? Yes. You just need to be able to substantiate it, which you can. So I'm fine with that. And you should allocate $8,333 for yourself, assuming you make over $100,000. How long will unemployment benefits have the extra $600 a week? For 4 months. That's what the government has approved. We already told our staff that we would give them holiday pay, and then an employee said she had to care for her son while she was on spouse. She's seeking the COVID diagnosis. How do I designate the benefit? Holiday sick, what? Well, the answer that I can tell you definitively is she does not qualify for all of the above. She gets one category. So she's got to pick. Is she home because she's seeking a designation of COVID and she gets 2 weeks? Is she home because she's caring for a child who's out of school? One way or the other, she's got to pick between which one it is. Now, if she's home sick for 2 weeks and then she's going to be home taking care of the child, you have to pay her for 2 weeks for the sick leave and then 10 weeks for the child care after that. If you have already fired everybody, then the answer is she's entitled to unemployment. So I've said this in prior conversations that we've had, where the slides actually worked for the beginning, and I'll say it again. The government has made a couple of different ways to make employees whole or partially whole for benefits. So it's either the employees are going to be paid on unemployment because you've terminated them. The employees are going to be paid by a potential forgivable loan that you may get, and then you can get forgiven. So that's hopefully not coming out of your pocket either. Or the employee is going to be, if they're home for a legitimate authorized reason, they're going to be paid by you potentially, if you're still running payroll and they're still employed at the time, for the COVID leave, and you will be receiving a dollar for dollar tax credit back. You do not get to avail yourself of all of the above benefits. The employee can only get one benefit at a time. If the employee is home for another reason, maternity or caring for a loved one for another reason, they may qualify for New York paid family leave, separate and apart from COVID, or possibly for COVID for additional benefits. So there's a lot of different things here that we need to be knowledgeable of. I'm an employee of a PC, for which I am the sole shareholder. Can I obtain unemployment? Nope, we already answered this one because your PC is open. What if the conditions don't warrant us bringing back the employees on April 26th to an ophthalmology practice? Again, the government is just saying, look, we're giving you money so that way they're off unemployment and they're back on your payroll and they're ready to work if you need them. So my concern isn't if you have no work for them on April 26th. If you get the loan, you're going to bring them back and you're going to keep them back because you have to keep them employed through June 30th. My concern is if we're not ready to be back full tilt at the end of June, and then you still have to carry them. But again, you have to carry them through June 30th, and then we'll evaluate. If we need to go back down to part-time with them at that point, then we will. The $10,000 grant is the EDL grant, and if you email me, I will send you the application. Okay, guys, there are a lot more questions. I think I will send Robin an email with some additional answers, and I apologize again for the technical difficulties, completely my fault. But I am available if you have questions. The best way to reach me this week is by email, and it is my pleasure to be of some service to you during this time. So I look forward to speaking to you, and I hope that you have a very healthy weekend. And thank you for all that you do for us. Talk to you soon. Bye-bye.